Good morning, everybody. Welcome, and thank you for joining our tax disputes webinar today. I hope you've all got a nice warm cup of coffee on hand. I'm Sarah Powell-Wilson. I'm the content manager at LexisNexis, and I specialize in tax and financial services content. Handling tax disputes with CSARS has become a hot topic for many of you tax practitioners, as CSARS is now questioning an increasing number of returns. So we are really very grateful to have Nico Taron sharing his wealth of knowledge on this topic with us today. Nico is also the author of our practical guide to handling tax disputes. And this book has had excellent industry reviews, including one by our facilitator today, Keith Engel. So before we get going, please allow me to just share a few housekeeping rules and the planned program. So all delegates will be muted for the initial sessions, apart from Keith and Nico. Keith Engel will introduce Nico, and Nico's presentation should take us up until about 11 o'clock. We'll then move on to the question and answer session. Please send your questions through using the Q&A tab, which you'll see at the bottom of your screen. And we'll try to get through as many of these questions as possible. You'll also see there's another little tab at the bottom called chat. And please reserve this chat box for general comments that are not questions you'd like to ask our speaker. We've allowed for around 20 minutes of questions and answer. So the webinar will be about 90 minutes in length. It will be made available to all the delegates a few days after the session. But if you're wanting more detailed commentary and practical guidance, then you can get it in the practical guide to handling tax disputes. And this is available on our e-store, and all of you, all the delegates will receive a 15% discount. So check our chat box for the bookstore address and the discount code. Right, so we are very honored to have Professor Keith Engel to facilitate this session for us today. As the Chief Executive of the SA Institute of Taxation, Keith really needs very little introduction from me, especially for all of you who are state members. Keith is also an honorary adjunct professor at the University of Cape Town, University of Northwest, and Rhodes University, and is well known for his leading roles in the formulation of tax legislation at National Treasury. So without more about Keith, as I could go on forever, I'm handing over to you, Keith. Thank you.
Thank you, Sarah. Appreciate it. Okay, yes. Keith Engel. I am the site CEO. I believe a number of the members are here with us from site, but there are also others that Lexis has brought in. And just to give you a little bit background as to who we are and why we do these things. I mean, we are a tax professional body. And as a tax professional body, we're the leading group who deals with CSARS tax practitioners. And we've got about over 8,600, 8,700 members and growing. Our goal is we're a specialist body. So there are other bodies like SICA and SIPA. And the bottom line is most people are an accountant and they're a tax person, a lawyer and a tax person. So we complement the tax side. Our goal is to work with the other bodies is for a value add. And part of the value add of being a regulator, and that's what we are, we regulate the profession, is also help the profession in their daily practice. A lot of times that requires government engagement, but a lot of them are webinars like this and providing material and getting access material so that members have the necessary information to do their practice. And what we're trying to do is make sure that we're giving them information and providing you with help, things that really matter on a day-to-day basis. That's what's really important. It's very easy to give webinars and seminars and all sorts of things that are just what you've heard before, or that gets very theoretical. But the bottom line is you have a daily job. And in your daily job, you need to be able to help your clients in a very basic, practical way. And a lot of issues are simply about e-filing, making sure you can submit things properly, and other things is just dealing with CSARS. And the topic here that's been discussed is really about tax disputes. And there has been literature for the last, about 5-6 years, actually. And that literature has basically been it's been very superficial. You've seen some acts on the Tax Administration Act, but that doesn't help you because a lot of the act is really meaningless stuff for you. It's really all about how SARS runs its processes internally. But there are elements of that tax dispute process which is very important. And so what many of you members are finding is that part one, so, excuse me, is really about, submitting the returns. And in the old days, you would submit your returns and you would file them, and then you get a few back and you would deal with it. But today, when you submit your returns, SARS is increasingly questioning things. So you might have a self-assessment system, but you'll get a verification letter, an audit letter. You'll be getting a lot of requests back, and you're finding that more and more of the work is happening after you file the return and not before. And what you find is a lot of people are good at the compliance element, but the next element of dealing with SARS becomes very challenging. And so what the purpose of the book and what makes this so useful is they're helping you do that. And that's really what it's all about. This book is very unique. I've seen other books, they're too theoretical. They just repeat the law. This one is very, very unique. So that's why I was very interested in this subject. And it's really been laid out in a very practical way. And so that's our goal, is to give you more and more practical information that helps you in your day-to-day practice. And hopefully you can feed that back to other members as well. So it's getting down to the essence of it. It's my pleasure to introduce Nico Theron. He's got many years of tax experience. I've known him at least 5 years now, maybe more. He is the founder and managing partner of Unicus. I keep always saying it wrong. Unicus Tax Specialist SA. It's a niche practice firm, and the main focus is dealing with tax disputes, which is becoming really where the action is. And that's been his focus for quite some time. Besides his wealth of experience, he's got lots of degrees. He's got a BCom Law, BCom Honors. He's got an MCom. He lectures at the University of Pretoria. He's done a lot of work for us directly. He's also done some work with what you'll see around as something called the Tax Faculty, which is another provider of CPD. And he's got quite a bit of experience. And somewhere along the way, I don't know how he did it, but he had the time through the COVID and through the work to prepare his book. And I was fortunate enough to be given the one to review it. And I can highly recommend this book. I think this book is really a very unique offering. It's only going to get better, and it's a solid book. It's laid out in a very practical way so that it matters when you get the right questions, or it's coming in as if you are a practitioner. And the bottom line is he's not just theorizing, he's done the work. So you need to be able to do that. And so if you don't have a copy, one of the things we like to give our members is member discounts. So Lexis is doing that for us. And I would really urge you to pick this book up. You're going to need it. You're going to find it's just what it is. You know that dealing with SARS back and forth is what it's all about. So while your taxes have to be paid, clients need to be assured that they won't be forced to pay any more that they have to pay, and that they know that they can deal with SARS free of penalties and interest, because that's really where the issues lie. That oftentimes you miss a deadline, you don't answer things a certain way, and they're not just coming at you for a shortfall or a suspected shortfall, it's the penalties and interest. And oftentimes that outweighs the underlying liability. So anyway, we're looking forward to hearing more from you about this. And I think that Nico is going to give you quite a presentation. So look forward to enjoy. And I encourage you in the back to put in your questions. Make sure you engage before, engage afterward. If you're a member, we also have a query service. And there it is. So take advantage of this opportunity. It's a unique one. And I look forward to it. Nico, handing over to you.
Thank you, Keith. Thanks for that introduction, and thanks LexisNexis for hosting this webinar. And welcome everybody to today's session. All right, so without further ado, let me just get my screen up here and let's get into today's topic. Right. So what I want to discuss today is I want to go into something in specific, and that's the issue of how to reduce the time and cost of an appeal. And before I get to that, and to get an understanding and put this all in context, I want to go back to the Ombud's report of 2020. So last year, the Tax Ombud did an investigation into some complaints about SARS not sticking to the dispute resolution timeframes, and so the Ombud went and investigated that, and I'll take you through some of that findings. But there's one important finding that deals with appeals and the objection process in general, which for me, dealing with tax disputes all the time, is probably one of the most important and significant findings by the Ombud. And I'll place that a little bit in context. And then I'll take you through a recent case where we represented a taxpayer in the tax court, which we effectively prevented an appeal and resolved the case without having to go through an appeal. And then I'll conclude with how it is you actually get to save time and costs of an appeal. I'm just going to switch off this. All right, there we go. All right, some interesting facts from the Ombud's report. You can go through those at your leisure, but bear in mind that the stats and stuff that I'm discussing today relates to the period investigated by the Ombud, which was 2017 and 2018. But there's some interesting facts about the number of objections, condonation applications, of course, where the objection was late, the number of appeals and condonation applications. You'll see the numbers are actually quite low, which is shocking when you consider the finding that I'll discuss in a minute. Right, so some of the general findings, and I think many of you would have had to deal with this in practice, is that SARS system doesn't count the days correctly when it comes to dispute resolution. Right now, a day for the purpose of Chapter 9 of the TIA, in other words, for the purpose of objections and appeals, is business days. And SARS don't count those days correctly. And in the result, you'll have SARS declaring objections invalid because it's late when it's not late, or SARS not complying with an obligation or time period to respond, for example, to make a decision. In fact, SARS did not timeously make a decision over the period investigated in 14,000 cases. I mean, it's not that difficult. They've got 60 days to make a decision. Bearing in mind, they've got roughly 3 or 5 years, depending on the tax type, to conduct their audit. So, I mean, making a decision on the objection shouldn't take all that long. Now, I can go through all of these, but I think they are pretty, I think most of you would have seen this in practice, and it is frustrating and it is often debilitating. But suffice it just for now to say that there are mechanisms available to taxpayers to keep SARS and hold SARS to account. And oftentimes the frustration experienced by taxpayers because SARS doesn't comply with an obligation is because they don't know what to do about it. You know, it's almost as if, well, okay, they did it, so what now? You know, there are remedies available and very effective remedies at that, including going to the Ombud that you can use to call SARS to account, and which can be very effective. And all of those remedies I also discuss in my book for where SARS doesn't comply with the rules, which happens quite often. Now, this is the finding for me that is probably the most important finding raised by the Ombud, and that is that in 92% of cases that went on appeal, SARS conceded to the appeal in full. Right. So in other words, SARS said we were wrong all along in 90% or 92% of cases. Now, I understand that this stat is in relation to 2017-18. Suffice it to say that we deal with objections and appeals and litigation stuff all the time against SARS. And I don't think that stat is really that overstated in the current circumstances. In fact, a more recent stat, when you look at SARS's annual report from last year, suggests that SARS concedes to 65%, which is still quite high. But to understand the gravity of this finding by the Ombud, we need to just place quickly the dispute resolution process in context, right? And I won't bore you too much with this. I think most of you are familiar with this. But we know that if SARS raises an assessment, the taxpayer can object to that assessment, or they can request reasons for the assessment, right? So if you first request reasons for the assessment, then SARS must provide those reasons. And the reasons that they must provide are the reasons for raising the assessment. And that will become clearer in a second when I talk about how we dealt with this recent case. The reasons for an assessment is the factual and legal basis on which SARS raised an assessment. So you can go and object straight, or you can ask for reasons first. Now, after you've objected, SARS can do one of three things really. They can declare the objection invalid, which I won't discuss now because that's probably a webinar on its own. So they can declare the objection invalid, or they can request further documents necessary to make a decision on the objection, or they can go straight ahead and make the decision. Right. Now, if they've made a decision on that objection, they must send, of course, notice of that decision to the taxpayer. And that notice, which SARS gives, must set out the basis on which they've arrived at their decision. Right? Whether that decision is to allow or to disallow the objection, they must tell you why they've made that decision. Now, once the objection has been disallowed or partially allowed, the taxpayer can take the next step in the process. And this is all prescribed. Right? So you have to follow these steps. There's another remedy I'll discuss later on, but for the most part, guys have to file an objection, get that objection dealt with. SARS needs to make a decision, send a notice, and then the taxpayer can appeal. Now, an appeal really is not an appeal, and this is very important to understand. An appeal in tax dispute resolution is not an appeal to SARS's decision not to allow the objection. It's an appeal against the same assessment that was placed under objection, and that's crucial to understand. There's some judgments where the courts, respectfully, I submit, got it wrong, where they say the taxpayer is appealing against a decision by SARS. That's not right. Really, an appeal is a post-objection remedy. If I can explain it like that. So you're still pursuing the case against the underlying assessment. Now, all appeals, really, as a starting point, are appeals to tax court, in other words, to litigation, unless the ADR process, the alternative dispute resolution process, or the tax board process intervenes by agreement between the taxpayer and SARS. Of course, there are some other requirements that says when a tax goes to tax board and when it goes to tax court and when it goes to ADR, but suffice it to say that one of the requirements for the ADR process and the tax board process to intervene is that there must be an agreement that the taxpayer will first go through that channel before it goes to tax court. Right. Now, the point I'm making is you always have to object first, and that objection must always be disallowed or partially allowed before you can file an appeal. Right. Now, to get to an appeal stage eventually, remember, all the while the tax is due unless you've got a suspension in place, but all the while the tax is due. Now, the objection process, depending on whether SARS declared the thing invalid or requested information, let's say best case scenario, you're looking at about 90 days, business days, right? So about 5-6 months roughly, before you can go ahead and file an appeal. And really, at appeal, that's where it gets a little bit more difficult and sticky, and where the dispute gets real. But the point is, you have to go through the objection process first. I recall a while ago, I spoke to a client we successfully defended the case. I was very frustrated with this process. So why do I have to object first, and then the SARS objection committee must make a decision, and then only we can get to litigation? Well, unfortunately, that's the process you must follow. Right. Now, really, to get to an appeal, to get the appeal dealt with, in practice is normally about a year, because most people tend to go to ADR first for some reason. In some cases it does work. I'm less inclined to the view that ADR works, but be that as it may. Right. So it can take a long time, and it's a lot of costs to get to an appeal. Now, if we go back to the Ombud's finding, right, bearing in mind that you have to first object, and that objection must first be disallowed. If SARS concedes to 92% of cases taken on appeal, right, that means effectively that 9 out of every 10 decisions that they made an objection was wrong, because they ultimately conceded that there was no merit in the assessment all along, right? So that is a very frustrating position to be in, to be forced to follow an objection process, and then be forced to file an appeal, and then be forced to deal with this protracted tax stiff slog, as it was called in a recent article, right? Is there something the taxpayer can do? Now, we're looking at 92%, right, that SARS conceded to. That also means that 9 out of every 10 cases where there was an assessment, the assessment had no merit. Right. Now, that just makes me think, what about those taxpayers who didn't actually challenge or go through the objection process and try and challenge an assessment? If 9 out of every 10 assessments that was taken on appeal was wrong, then what about the cases where the taxpayer didn't challenge the assessment? Now, when you look at the annual report of last year from SARS, right, and I know I'm not comparing apples with apples, but it just gives you an idea. So when you look at SARS's 2020 annual report, it suggests that only 20% of the outstanding debt that SARS has, in other words, money that was owed to SARS, only 20% of that debt was placed under objection, right, or was under dispute. Now, that begs the question, if 9 out of every 10 assessment is actually wrong, and only 20% of all the debts in dispute, how many disputes have not been filed that should in fact have been filed? You know, the guys are simply not challenging the assessments, and it turns out that most of them are wrong. Apart from the fact that it's frustrating, it's a waste of time and costs to deal with this process if it was wrong all along. And it seems to me, to some extent, that some taxpayers tend to think that SARS can't be wrong. You know, the assessment is right, let's just pay it, let's just get it over and done with. Well, the Ombud's report suggests that's not the case, right? And part of the reason I think why guys might be reluctant to dispute an assessment is ultimately when you do go and appeal and you look at the annual report, there was about 52 judgments in favor of SARS, eventually those that ended up in court, and 12 in favor of taxpayers. But that also begs the next question. If 9 out of every 10 assessments has got no merits, what went wrong in the dispute process? How do you lose the case if the thing 9 out of 10 times have no merits? So that also raises some questions about the efficiency of the cases being disputed and how well they're being disputed. Right. So that to me is important to understand. So now what you've got is you've got SARS forcing you through an objection process, which is as the law prescribes. You have to first object, and it has to go to an objection committee, and they need to make a decision and send you the notice, right? If they decide not to allow the objection, you can't object to the decision not to allow the objection. Your next step is to file an appeal, but you often find that taxpayers are being forced into appeal when the assessment has no merit, almost as if the objection committee or the guys who make the decision on the objections don't properly apply their minds, and then they just disallow the objection and say, well, we know the taxpayer needs to go ahead and file an appeal, so let him go and do that. Right. So that brings me to a recent case where, in my view, SARS was doing exactly that, and I'll explain to you how we avoided an appeal and resolved the case completely. All right. So this taxpayer that we dealt with here is an investment entity, and it trades amongst others, or mainly really in derivative instruments, financial derivative instruments like contracts for difference, single stock futures, securities lending arrangements, all those complicated, fantastic, and wonderful things in the finance industry, which is indeed very fascinating, bearing in mind that when you think about the tax treatment of these things, there is no authority on how they should be taxed, right? So the law is very much unclear as to how you go about declaring and taxing these things, especially with regards to the title. So anyways, so SARS came about and they said, fine, we do an audit, and they decide that they raise an assessment. They raise an assessment over a couple of years, if I remember correctly, about 4 years or 5 years, over which they raised the assessment with penalties, and that assessment came to a couple of 100 million rand. Right. So now, really the basis for SARS's assessment, or the main basis for their assessment, was that SARS held a slightly different view as to when the tax event triggers on these derivative instruments, and as was held by the taxpayer. The taxpayer declared everything, but on a different timing event. So SARS took a different view as to what the taxpayer's position was, bearing in mind there is no authority on how these things should be taxed. Importantly, by the time SARS raised these assessments of a couple of 100 million, half of which was penalties roughly, the assessments had prescribed. Right. So what we did initially is we filed a request for reasons, and that was partly for strategic reasons and partly to clear out a couple of things. But we nevertheless filed the request for reasons, and really the strategy behind that, for the most part, is to crystallize the issues in dispute so that we don't get surprises 2 years later where SARS says, no, but hang on, we actually think this is the reason for the assessment. So asking for reasons for the assessment is extremely important, and we asked for reasons. Right. So SARS eventually delivered their reasons, and we filed an objection. Right. Now, this objection spanned some 106 pages and contained roughly 14 different arguments, most of them aimed at rendering the entire assessment incompetent or several material parts of it. Right. So they were all raised in the alternative to each other. So they were all 14 different self-standing grounds for assessment. Right. And unfortunately, the facts of the case are complex because we were dealing with volumes of derivative instruments, and we were dealing with difficult contractual terms, and in a space where the law has got really no clarity on how these things should be taxed. Right. So we filed the objection. This 106-page objection, 14 different arguments, some of them raised on procedural grounds. Long story short, we filed it. Right. Then eventually, SARS obviously has to make a decision on this objection of ours. And I remember the day on which the outcome of objection fell due, or the day after, we just sent them a mail and said, listen, you haven't sent your outcome yet. By the way, your period to do so had lapsed yesterday, or something along those lines. The point is they were late. And they obviously realized that that's a problem, and they quickly decided to make a decision on the objection and delivered the outcome letter, in which they set out a basis. Let's put it at that, if we can go that far. They set out a basis for disallowing the objection. Now, this notice that SARS sent was a notice to partially allow the objection. Really, the saving or the reduction was nominal, but it was a partial allowance. Most of the stuff was still in dispute. But importantly, the notice contained or was a 3-page document purporting to respond to a 106-page, 14 different argument objection. It was immediately clear to me when I read the outcome of objection that SARS had not applied their minds to the objection, and that they were simply forcing this taxpayer to go on appeal. Right? And the chances are, and in my view, the assessment had no merit to start off with, the chances are we're going to get to a concession a couple of years down the line, bearing in mind that this would probably be an appeal to tax court, and it would probably take years to resolve. Right, but they were just pushing us into appeal. And I understand part of the reason for that, but they can't do that. Right, but now the problem is, when you look at the rules, it says you have to appeal. Right, now, we were sitting in a position where we said, fine, clearly they haven't considered this objection properly. They're just forcing us to go and appeal. But do we really have another option? Is there something else we can do? And yes, there is, but there's a few risks to it. We all know that if you don't file an appeal after the objection has been disallowed, that assessment will eventually become final. Also, bear in mind that you have a maximum of 75 days after a notice of objection or notice of outcome of objection was delivered to file an appeal. After that, you're dead in the water. SARS can't extend it, the tax court can't extend it, and I'm not entirely sure whether the High Court can extend it. Right, and you can look at the Danwood case if you're interested in that 75-day maximum extension. So clearly, it felt like we were being bullied into filing an appeal, because if we don't appeal, we could run the risk of inadvertently finalizing this case of a couple of $100 million in favor predominantly of SARS. Right. So now, is there something we can do? Yes, we can appeal, but really, can we? Now, let's just recap a little bit. What does the rule say when you file an appeal? Right. So you have to file this NOA or ADR2 form, and in that form, you must say, what is it that you are appealing against or maintaining in dispute? And then you must set out in detail, why are you disagreeing with the basis for SARS's decision not to allow the objection? Now, given SARS only responded to 4 of the 14 self-standing grounds for objection raised, how do I respond in my appeal by explaining why I disagree with the basis for SARS disallowing the objection? I can't really, because no basis was given, right? And also what is important is when you look at section 107 of the TAA, it says that an appeal that doesn't comply with Rule 10 is invalid. So really, I was sitting in a position, or we were sitting in a position where we said, okay, well, I can't really appeal. Even if I do, that appeal would be invalid. And if I don't appeal, then, well, I run the risk of finalizing the case in favor of SARS. So, what do we do in this period? How do we deal with this time period? And now enter Rule 56. Right. Rule 56 of the rules, in broad terms, says that if SARS fails to comply with an obligation, or a taxpayer for that matter, but in context SARS, if SARS fails to comply with an obligation or time period prescribed under the rules, then the taxpayer can apply for default judgment. Right. Now, what does that mean in layman's terms? All that really means in layman's terms is if SARS doesn't stick to the rules, then you can go to the court and ask for relief. And the relief you can ask the court for is either an order for SARS to comply with an obligation. So in this case, it would be SARS, you are ordered to give the taxpayer the basis for their decision. Or you can ask for final relief. That's very important to understand. So in other words, you can say SARS failed to comply with an obligation. I want the court to make this case final. In other words, allow my case altogether, just because SARS failed to comply with an obligation. Now, there's a process you must follow if you want to do this, prescribed in Rule 56, also set out in detail in my book in Chapter 11. But what it says is, it says that you must first serve notice on SARS. So you must tell them, SARS, you failed to comply with this obligation, and I intend to launch a default judgment application. They then have 15 days to fix it. If they don't, you can proceed to court. If they do, well, that takes away your cause of action and you move on with the dispute. Right. Now, bear in mind that we have 30 days to file an appeal, right? 30 days. After that, you must ask for condemnation. And really, on a case like this, you don't want to be on the back foot by asking for condemnation. Right. So we immediately realized we need to file this notice to give SARS the 15 days they need, or I have to give them, to fix their mistake. And really, if they had fixed the mistake, I would have also gotten the result I wanted, because all I wanted is for them to apply their minds to the objection and not forcing me on appeal. If they had done that, then they would probably have allowed the objection anyway. So it's just pushing the matter back to them and saying, don't look at it again. And if you don't, I'm going to go to court. Right. Now, we have to give them 15 days notice. And then once we file the application for default judgment, that 30-day period in which we have to file an appeal is suspended until this default judgment case is eventually resolved. Right. So that's what we did. And our argument really was that SARS, you are obligated in terms of the rule to provide a basis for your decision. Right. So you've got an obligation to give me a basis for your decision. You didn't do so. Here's your notice, and the time period will be suspended. So the strategy we used, or the process we followed, took care of all those risks we had of not filing an appeal. So just to take you through the history of the case, we served notice of intention to apply for default judgment, and SARS then responded with, well, it was first a telephone call, which I won't say too much about, but they sent a formal letter where they said that, effectively saying that my intended application for default judgment is baseless. You can't do that, right? That's not what you must do. In fact, taxpayer, you must ask for reasons in terms of Rule 6. And if you go ahead with your intended action, we will vigorously defend. Now, that's not a threat to take lightly if you're dealing with a couple of R100 million dispute, right? So now the question was, okay, fine, SARS is responding to our notice. Remember, they've got 15 days to fix this. They are denying they're in default, calling the application baseless. They're going to vigorously defend, etc., right? But they're saying, we can't do this, we must do something else. We must, if we're not happy, they didn't give a basis, then we must ask for reasons for the assessment, or reasons for the decision, and we must do so in terms of Rule 6. Now let's just revisit Rule 6 briefly. I discussed it earlier. Rule 6 says you can ask for reasons for an assessment. That's something completely different to the basis on which you've disallowed the objection. If you could just, in your notice of outcome, repeat the reasons for the assessment, then what's the point of objecting if you didn't apply your mind? I know you have reasons for the assessment. That's why I objected, and that's why I explained in my objection that your reasons are effectively wrong. So you can't say to me, I must now ask for reasons. In fact, I can't do that because the period to lodge an appeal also wouldn't be suspended if I did it. That's not what Rule 6 is there for. Right. Nothing from SARS after, well, they sent this letter. And we then responded explaining to SARS, listen, we can't really do Rule 6. Right. And I explained to them in detail why they are in fact in default and why the application isn't baseless, and invited them to request an extension to the 15-day period so that I don't have to go ahead and launch this application. Bearing in mind, if they had actually accepted they're in default, asked for an extension and properly applied their minds, which would take them some time, to go through the objection, I was pretty comfortable that objection or that decision to disallow would be changed over to a decision to allow, because it was clear they didn't look at it. So that's why I was willing to give them an extension. I did not want to bring this application. I wanted them to look at my objection and not force me into appeal. Naturally, after that letter, SARS didn't respond. And we nevertheless, in trying to amicably resolve it, despite the fact that there was no basis in law for doing it, we said, okay, fine, you still have this 15-day period. I think at that point there was about 6 or 7 days left of their 15-day period. So we filed the request for reasons, not in terms of Rule 6, but just really a question. So can you please then give me the basis? But we said to them, if you give me the basis, if you are willing to give me the reasons for the assessment, despite the fact that the rules don't allow for it, I will give you an indefinite extension to this 15-day period so that I don't have to bring the application. But all you have to do, SARS, is just accept that you are in default, right? I want you to confirm in writing that you are in default. And what that would have done is it would have prevented the 30-day period from running, because then I wouldn't have launched the application per se, because I'm still within that 15-day grace period, which indeed you can expect. So what that would have done is it would have prevented the need for us bringing the application to suspend the period by operation of law, and we would effectively suspend the period because SARS accepts that they are in default and that they will now go and apply their minds and come back to me with a proper reason. Basis for the assessment. SARS responds, fortunately that time, they respond and they ask us to give an extension. Right. So no reason why they want an extension, they just want an extension. And really bearing in mind, we're in a position where they haven't yet confirmed they're in default. They're continuously denying. I haven't launched the application yet because the 15-day period hasn't lapsed, and they haven't confirmed that they're in default. So I'm sitting in a catch-22 where they could span this period out and push me into a condemnation process. Right, so I said, okay, fine, can you just, you're asking for an extension, you're not saying how much time. This is the problem I have. You've got 15 days, 30 days suspension, etc. Can you just tell me how much time you need? To that, we received no response, lo and behold. We nevertheless, in light of that, having no other choice really at that point in time, executed and delivered our application for default judgment. SARS fails to oppose in time. There's another default, again missing a deadline, and the case is eventually set down for hearing. SARS fails to oppose. We file a draft heads of argument, and 3 days prior to the date for the hearing, we get a notice to oppose in the High Court, which is wrong. It should be in the tax court. That was later fixed, right? But you can see they quickly realized they have to oppose it, so they put something together and they sent out the notice. We took note of that. The notice to oppose doesn't really do much. I want your answering papers, which we never received. 2 days prior to the hearing, SARS says, no, SARS would like a meeting with us to discuss what's going on here. Bearing in mind, we filed a 106-page objection. They've had their 60 days, and it was quite longer actually because of COVID. There's quite an amount of time that they had to come up with a decision, and now they want a meeting to discuss this. Of course, at that point, the taxpayer is not very willing to agree to a meeting with SARS, given that this has been quite a process. And as opposed to agreeing to a meeting, we respond with 2 draft orders for SARS to consider the day before the hearing, so that we don't have to waste the court's time. Because really, at that point in time, we're going to get 1 or 2 orders. We're either going to get an order to compel SARS to comply, consider the objection and give a basis, or we're going to get final relief, to which they never responded, and we nevertheless have the application heard in the tax court. And what we get in the tax court is final relief, right? What that means is the court said, fine, SARS, you are in default. Taxpayer launched this application. Taxpayer is asking for final relief because we did ask for final relief. And the court gives us final relief. So the court says, fine, I will order the additional assessments back to the original assessment. So you're sitting with a couple of 100 million rand in liability that's being reduced back to the original, and the original assessment for all assessed losses to the tune of a couple of 100 million. Right. Now, effectively what this process did is it stopped SARS from forcing my client into an appeal process, which would undoubtedly have ended up in court. And no matter, given that there's no authority on how these things should be taxed, I suspect that no matter which way judgment went, if we had to file an appeal and eventually go to tax court, it would probably have been appealed further, right? So that a proper precedent can be set, right? So what we effectively achieved is we prevented the appeal. It's a wholesale win of the case on a default judgment application. And it took us roughly 5 months from the date that SARS sent the notice to disallow the objection to the date of the court order was roughly 5 months. And not only did we win the case in the tax court, we got a cost order as well. So what this process that we followed meant that, first of all, no appeal is necessary because we won the case on default judgment. The cost of the appeal is 0 rands, which would have been a couple of million if it had to proceed to litigation. And because we got a cost order, the cost of the application is effectively also almost nothing. So here, what we did is we followed a default judgment process and stopped SARS from forcing the client into a dispute. This case is unreported. It's also unprecedented as far as we know. It's never been done before on this basis. Right. So the takeaway from this is you have to look at the outcome of objection, right, and see what they are saying, because they have to tell you why they are disallowing the objection. So they must apply their minds and say, okay, and I'm not saying if they give a proper answer, go ahead and file this, well, you can't anyway, or go ahead and appeal. If the answer is proper and it makes sense, well, just abandon the case. There's no more point in pursuing the thing. But if they just ignore you, which is often the case, then you've got the option of going for default judgment. But the question is, what is the default here? The default was a failure to give a basis for the outcome of an objection. What exactly is a basis? Because you can go and look in vain. There's no definition of what that is. But when you start reading the rules that govern dispute resolution as a whole, right, then you start getting a better understanding of what a basis for the decision is to disallow an objection. And our argument was that a basis for disallowing an objection must be the factual and legal basis on which SARS decides not to allow an objection. And indeed, also to allow an objection. And you might say to me, well, who cares if they give me a basis whether to allow the objection or not? That's not really relevant. It is very relevant. When you think of prescription, we all know prescription says 3 years, 5 years, etc., etc. But an assessment also prescribes if it's issued following resolution of a dispute under Chapter 9. In other words, if it's a reduced assessment after you won a case in tax court or after you won a case in objection, to be more correct. Right. So now, if SARS does not set out the factual legal basis on which they've allowed an objection, how are you going to know what exactly prescribes under Section 99(1)(e)? You won't know. So that's why we said it has to be a factual and legal basis. SARS at one point alleged in a letter somewhere that it's not a detailed basis. That's not what we were arguing. We were arguing that it must be a factual and legal basis. That's the only way you can comply, right? Now the question is, when can the court give final relief, as it did here? Now our interpretation of the rules, and that also was the argument, is simply in the absence of good cause shown by SARS for failing to comply with its obligation. That's it. In the absence of good cause shown by the defaulting party for its default. In other words, in the absence of SARS explaining for good reasons why they haven't given a basis for the decision. Right. Then the court can, in my view, grant final relief. The court seemed to be quite reluctant. There's a couple of judgments which SARS was nice enough to release earlier this year about default judgments. All of them are lost, where the taxpayer lost. This is an exception, but this is an unreported case. If you don't hear it from me, you wouldn't have known about it. Right. So now, in the beginning of the session, we said this is about how to reduce the time and cost of an appeal. In this particular case, and I think we can definitely duplicate this result across many cases. If you don't file an appeal, you go with the default judgment route. In the right circumstances, be careful not to launch this willy-nilly. You could end up being much worse off. It has to be very carefully orchestrated and executed to make sure you don't end up in a nightmare. But here, by following a default judgment route, we prevented an appeal which would have dragged on for years, would have cost millions of rands, and the cost of the application was effectively nominal compared to what this case would have cost had it gone on. Right. So be careful when you try and consider this as a remedy. You have to understand that this worked, in this case, in my view, partly because of how the objection was drafted. The objection here was very detailed, very crisp, very much to the point, and very much dealt with the basis in law on which the argument went in. Right. So if you file a terrible objection and SARS gives you a terrible answer, chances are you're not going to be successful with the default judgment application. Right. It has to be properly executed. Right, and you have to pay very careful attention to the 30-day time period. So the rule is that 30-day time period only gets suspended from the date you file your application for default judgment. Given you must give SARS 15 days, which doesn't suspend the 30-day period, to remedy their default, you need to be pretty quick on the trigger to make sure that once that notice of outcome falls, you make the decision and you execute, because you might end up in a terrible position. Because if you lose the case, of course, you go back to the appeal, and it has to progress through the process. If you are late, then you have to ask for condemnation, all sorts of things. Now, You might say to me, okay, Nico, this is all good and well. You managed to win the case on a procedural basis, unprecedented, fantastic. But can SARS not appeal the judgment? Now, there's this Wingate Pierce case. I think it's 2016 or 17 from the FCA that said that the tax court is a creature of statute, and so you have to go and look at the TAA to see which of its judgments are appealable. And it ultimately said that interlocutory judgments are not under the TAA appealable. I know there's probably people jumping up and down about the common law. The fact is the tax court is a creature of statute, and interlocutory applications and judgments rather are not appealable. But when you look at the rationale for that judgment, yes, indeed, a default judgment application in which final relief is granted is indeed appealable if they had wanted to appeal, which is not going to happen, let's be honest. All right, in this case. Okay, so is there something else you can do? Yes, there is something else you can do, potentially, as opposed to going through this objection and having the objection disallowed and launching default judgment application. Yes, you can go to the High Court directly, right, under very certain circumstances. Now, there's a recent case out, Absa Bank and another versus SARS from the High Court, I forget which one now, where a taxpayer approached the High Court directly. So it didn't go through an objection process, because even though Section 105 says you must do, you have to object, appeal, etc., etc. But you have to follow the TAA rules ultimately. In Absa, the taxpayer did go straight to the High Court, and this is the first judgment I've seen from the High Court where the court is actually willing to entertain a High Court challenge against an assessment. In other words, allowing the taxpayer to challenge the High Court as opposed to objection, appeal, tax court, High Court, SCA. Right. And the court in this case said that the court will allow it, right? So it will allow you to challenge an assessment in the High Court, apart from the fact that it's expensive, guys. I mean, it's, but it is another option, right? You can go to the High Court if in exceptional circumstances, and the court says exceptional circumstances are, for example, as was the case in Absa Bank versus SARS, is where the issue in dispute revolves only around a point of law, which it did in that case. And what was interesting about this judgment, and I have to be careful because I'm dealing with another case that's also going to court soon, but what's interesting about this judgment is it says that if a taxpayer, or that's my reading of it, it says if a taxpayer accepts the facts on which SARS bases an assessment and only challenge the assessment on a point of law, then the High Court will hear it, right? What the SARS tried and argued in that case was to say, but hang on, it has to go to tax court so the taxpayer can give evidence and we can cross-examine, effectively saying to the court, but hang on, you can't deal with this issue just on a point of law. There's some facts that we still need to go and audit, but we'll do that in the tax court. And the court said, you can't do that. You've satisfied yourself with something, of a set of facts existing. That's why you raised the assessment. The taxpayer is not challenging those set of facts, it's challenging the assessment on a point of law. And so indeed, under the right circumstances, it is allowable to challenge in the High Court, but I think it is a little bit more expensive than going through the appeal route. So this was a case where we relied on a particular remedy to resolve the case in what was effectively record time, given the quantum and the complexity of the case. And I thought it would be good to share that with you, because I think it happens often. You know, when you get an outcome of objection, you often find that the objection wasn't properly considered. And that's quite scary when you think about it, given that the decisions are made by objection committees, meaning more than one person got it wrong per the Ombud 9 out of every 10 times. And so don't be forced onto appeal just for SARS to concede later, because if you do that and the case is conceded to by SARS before the matter is set down in tax court, bearing in mind you first have to go through ADR, where cost is possible in theory, but let's be honest, that hardly ever happens, right? So you have to go through ADR or tax board, and then you eventually get to tax court. I don't know. It's a bit of a long process. Anyway, so there are remedies available, not only default judgment, there are various remedies available to taxpayers to challenge assessments and decisions by SARS. And in my book, I go into detail on each of those remedies and why you want to rely on them and when you can't rely on them, and what you must do if SARS ignores the fact that you're relying on that remedy. One point in particular, a remedy that I can mention that's discussed in detail in chapter 6 of my book is if you ask SARS for a reduced assessment under 93(1)(d) or E for that matter. The problem with that is those are notorious for being disallowed by SARS. It's notorious for being ignored, in fact, in many instances. And so what we do in the book is I explain how you rely on that remedy and what you do if SARS ignores it, but more importantly also what you do if SARS doesn't grant you. What is your next step? What do you do next? There's always a next step, and you can always continue the challenge. And all of that I discuss in the book in detail. Right, that brings me to conclusion of that particular case, and the case we dealt with. I'm sure you guys have some questions. So Sarah, shall we move over to the Q&A? Right, I just want to try and stop this. There we go. Right.
Thank you. Keith, are you ready to start rolling with the questions from the delegates?
I'm fine. I can't seem to unmute my video. I thought you were able to see me at some point, but if you want to keep me off the system, all right, let's start my video. Okay, I'm just there. I'm right here. Hello, everyone. I was there just a bit ago. Okay, yes, no, that was a very good, informative discussion of the basic process, Nico. I must say you've been through a ringer, and I'm sure you've done it many, many times. That's where it's at. Let's go through a few of them here. I'll go back a little bit to just see which way we're going on this. Let's first ask, I'm just going to ask some quicker ones, and then I'll ask the VAT one. The VAT one is a little later. So first question that was being asked was Fricky Diagers asked a question about recovering costs. That, yes, you can do a dispute. The problem for a lot of people is, sure, you can have a dispute, but once you do that, it's going to cost you a lot of money. And some people are conceding simply because the amounts are too small to worthwhile to dispute. How often does taxpayers get cost recovery from SARS? And how easy is that? It seems that it's pretty rare.
Yeah, it is indeed very rare. When you think about what the rules allow for cost recovery, so it's the same with most courts. The costs normally follow the result. That's if you go to court, right?
Yeah.
When you dispute the SARS pre-appeal, really there's nothing in the rules that allow you to recover costs from SARS. That's going to probably be some form of delictual claim for damages or something to that effect. Good luck with that, right? When you go on appeal, technically speaking, when you go to ADR, which is an often relied on process when guys go on appeal, is the rules do allow you to agree on costs, right, in an ADR agreement, but also good luck with that, right?
Exactly.
So the tax board, when you go to litigate with the tax board can't award costs, right? So really, I mean, it's only the tax court, and really only after the case has been set down, we can start recovering costs through a process of litigation. And that will also only cover the cost of the litigation. It won't cover the cost of the objection. So look, I mean, unless you follow this default judgment process, and then also you can get costs, if it's appropriate, of course. Don't just go ahead and willy-nilly institute action. But yes, it is a problem. Costs is a problem. But in this case, I understand it was a significant quantum in dispute. But in this case, really, the appeal, like I said, cost nothing because there was no appeal to be filed because we won the case on procedure. Yeah. And the cost of the application was also pretty much nominal because we got a cost order. So in that case, it worked out well. But I understand it is a problem. And it's always something that I consider, when we start thinking of taking on the case, is the benefit going to outweigh the cost? And if so, maybe it's not worth it. Maybe it's worth settling. But that also is a problem because that allows for some bullying tactics. And I can assure you those happen as well. They know very well the case is not right for trial or something like that. So they would just press ahead. But there are remedies available, and some of them you can recover costs and some not, unfortunately.
Yeah, no, but I think you've got it right. I mean, the bottom line is that if the money, the sums aren't that large, the question is, you're trying to be careful with the client. But on the other hand, this was a lot worse under the Magnani era. But what you're basically seeing is people saying, okay, I'm making a trade-off here. I don't think you're right, but better to pay it off because it'll be cheaper to pay the low cost that I owe, well, not that I don't owe, than to fight it out. And so, but you're right. So there's not really much you can do. And when you get to court, it's only then you can get costs, but you're only getting costs related to the court. And I'm sure even that's a little limited. You can't just claim everything. Now, on the other hand, SARS needs to enforce. So if they have to pay costs all the time, the real problem is if you have unskilled people, and that's really where it comes down to it. That's what you see over and over again. Now, the other question that was raised. Go ahead.
Sorry, you also see what we're seeing often is kind of which I guess is not new. It's almost like it's a stall tactic, or a delay tactic, because of costs involved. They would launch striking out applications and all sorts of interesting things that stalls the process. And of course, it just keeps on adding to the costs. Of course, eventually, if you get everything resolved, you win, then you get that costs recovered. But it really is a question of who's dealing with the case, and then you can make an informed decision. Is it something that we're going to proceed on, running the risk of indeed getting a cost order against you, because that's always also possible. But it's really a self-assessment, to use the word in the sphere. It's really a self-assessment where you go out and say, okay, fine, given the facts and the merits of the case, what are the chances of this going wrong, or going south, or going this way or that way? And constantly playing chess, with what it is you need to do next. But yeah.
Now that's definitely right. Look, it's a constant calculation of probabilities. There's just no way around it. But unfortunately, look, it's a difficulty, because if you're telling me 9 out of 10 cases don't have merit, then really that's very scary, and it shows a real problem with the risk engine. And that's really what they're struggling with. They've been struggling that with more than 10 years now. That they really have a risk engine problem. They don't know how to even identify the risk, and then once you're at that risk, they get stuck in, and they kind of don't know. They've spent so much time, just as a matter of their own internal governance, they got to keep going. The other one that was not raised, that it was raised by Freaky, says, what about the pay now, argue later rule? So because now that's also the issue, because now you're fighting to get your money back. So how did that go in that case? Or
right. So that was a concern in that case, but we did effectively deal with it. So as we all know, there's the pay now, argue later rule. And when you think about the span of this case, it was about, I stand to be correct, it was about 18 months. So you're sitting with a liability of a couple of $100 million on the account. And of course, SARS can try and collect that unless you do a suspension request. Now, the trouble with, not the trouble with suspension requests, for the most part, they work. I mean, SARS for the most part would allow those requests to go through, depending. If the taxpayer's got outstanding returns, you can almost forget about it. They're not going to grant suspension, right? There's a way you can deal with that by filing subsequent requests, but you can't abuse the process, right? So you've got that automatic 10-day suspension. So if you take that into account, you can file subsequent requests, each addressing the first problem on which it was disallowed. So in this particular case, SARS never actually granted suspension over the entire 18-month period, but in the way we dealt with the suspension request, they never actually collected a single cent over the whole 18-month period, because the way in which we dealt with the pay now, argue later rule, suspension request, they've got a problem, fine, another one will fix it in this period, let's have a meeting, etc., etc. So if you've got outstanding returns or something like that, it is difficult to get those through. But if you're compliant, apart of course from the outstanding tax debt, then SARS tends to grant suspension.
So it's a little bit more flexible.
Or if you grant security. So if you grant security for the tax, and it seems to me that they are, for the most part, satisfied if you grant security for the capital tax, so excluding penalties and interest. Right? The way in which they want security depends, but that is something that we did offer in this case as well, is security for the capital tax, which was difficult at times, given the nature of the activities of the entity. But that's how we dealt with them in this case. And of course, if you do a suspension request and SARS disallows that request, you've got one or two options really. Find another one, address the reason why they disallowed the first one. Or if you think they are making the wrong decision all the time, you can have that decision reviewed in the High Court. But that's a High Court application. So what you would do, how it typically works in practice, SARS disallows the suspension request, assuming you think that's unreasonable, you would file an application to review and an application to stay collection pending the outcome of the review application. So just to keep SARS at bay whilst the dispute is pending, but you're certainly not powerless.
Well, that's quite good. It sounds that, Because I mean, there was a period there where a lot of those were getting denied. But yes, you can go to court. So it depends again the amount of money that's worthwhile. But you can do something. But it's important to know there are. The thing is, when you look at the Act Code, it doesn't look like you have options, but you tend to. And I think that's why it's very important you have a tax dispute person, because they're gonna. A quick reading ain't gonna get you there. You've got to realize that there's a lot of hidden things where you can go to the court, you can go somewhere else and keep yourself fighting. So
And
very, very
oftentimes,
important.
oftentimes it's not even necessary to go to court. If you know where to look and you understand SARS systems and processes in terms of know where to look in the TIA, and you know which buttons to push, then you'll probably never end up in court. It's just a question of how you place the case strategically, given the fact that SARS is who they are and they do what they do. And the lower level people aren't going to make this sort of decision. So you need to file a Section 11(4) notice, for example. So you've got to institute proceedings in the High Court. Chances are you'll never get there, because now you've escalated the matter in a strategic way, where you are ready to go, but the chances are unlikely that you'll end up there. And if you do, well, then of course you have to go, which is fair enough. But there are remedies apart from litigation, and if executed properly, they are very, very powerful, like default judgment. I mean, most default judgment reported cases, at least, are disallowed. They are not allowed because you can understand why. The courts are saying you are bringing a couple of $100 million case before me and ask me to allow your case based on a procedural issue. The courts are reluctant to do that. It depends on how you angle the case and how you pitch it, and how you set it up so that you don't have to end up with that result. But
it does require, though, a little bit of understanding SARS internal ops. You've got to know that as well. If you don't understand the structure that's going on, you don't know how to make an appeal. So that's not in the TA. That's a little bit of experience and a little learning, where you've got to do that. Very, very important. You find that people who are, as you said, rushing straight to the court, they're missing too many options. They don't really know how SARS works. That's why it's very important to understand their organogram and when it's time to appeal and when they won't make a decision and all of that. Just now, there's some questions here. Our friend the VAT, of course, is beginning to emerge. I found that VAT was improving, but I can see when I'm picking up from members and I'm picking up in the press and get calls from various members that our friends at SARS have now begun stopping refunds again. So the question then becomes, all right, well, here's the one that was raised by Nikki Kennedy. Okay, now SARS raised an assessment and did not allow one of the invoices. There was nothing wrong with the invoice, but they saw something wrong with it. You know how that is. Every once in a while, they see a defective invoice, which isn't defective. I'm not sure what those are. Maybe it's not in the right format or something. And so there they are. So then what's happened is the taxpayer goes, well, we don't agree with you. Give me your reasons. And then they say, well, Section 12B. Now, again, I'm not quite sure if 12B is relevant there, but they did notice the objection clearly ended 12B was not applicable. So now what do we do? If the reason like 12B, which is just totally insufficient, is how do you deal with the reason that's just bogus or just so superficial that it's not a real reason?
Right. So look, I mean, you can if I understand the facts correctly, SARS raised an assessment and you've asked for reasons and the reasons came back and it's nonsense. That's what I'm getting. Right? So you can approach the tax court also on motion to force SARS to give proper reasons, right? And for alternative relief, right? So that might be a way to deal with it. The other way to deal with it, depending on your appetite, is to say, okay, fine, well, you say that is the basis for your assessment. I'm going to go and object to that because I know it's not going to fly on 12B because that means nothing, right? It's not applicable. So eventually you'll get the case through, and that might be a cheaper option than going the application route in the tax court, because you can ask the court to order SARS to give proper reasons, right? Or one could try and say, well, the reasons aren't proper, I want default. But again, that ventures into the unprecedented space. So that's something that needs to be considered properly. Or, I'd like to ask for reasons for an assessment. If anything else, if you give them enough rope, they'll hang themselves with the rope, right? So the idea of asking for reasons is to try and crystallize the issues in dispute. So if you say, SARS, you've raised the assessment because of 12B, whatever that means, then I'm going to tell you that it's wrong on 12B. Now, of course, they will change their minds and they will say, oh, but that's not what we meant, etc., etc. And then there's remedies you can try and, or you can rely on to hold them to that ground for assessment. To say, well, you can't now, because I've now instituted an objection on this ground that you've given what you call a ground, which is nonsense. You can't, as was held in that Brumeria Renaissance case, although it dealt with prescription, the point is SARS can't keep changing their grounds for assessment until they eventually get it right. You know, they've given this is a ground for assessment, so that's the ground I'm going to hold you to. If you want to go and audit me again and try and do another ground, sure, we'll deal with that as well. Good luck with that, by the way. But you have to keep them to this ground, and that can be tricky at times, but it's definitely doable. You'll effectively launch eventually if they want to change their ground, eventually, because what you'll do is you'll say, well, 12B is simply not applicable, it's nonsense. And then they'll give you reasons for disallowing the objection different to the grounds for the assessment. And then you can start saying, okay, I'm going to set you up for failure on an application to strike, or whatever the case might be that's going to come out next. But there is ways to deal with it.
Well, let me just ask you here. I mean, one of the things on objection and appeal is making sure that you raise the right objections. So if you don't raise the right objections, and if they don't raise the right position on their side, you're kind of locked at a certain point. Where, you know, so, I mean, that's the question I'm having. Let's say, you know, typically things happen at the objection appeal stage. You've made a lot of arguments. They made a lot of arguments, but you found something that you go, wait a minute, I see that, you know, now I'm going to court. I think there's another position I would like to raise, or SARS would like to reposition. How locked are they into their administrative level? Is there a point where they can try to make a deviation, or it's too late and you're screwed?
No, you can. There is room for both taxpayer and SARS to deviate and to move out of that. And that's something that in practice happens often, Keith. I mean, if you think about it, you know, when an assessment is raised, it's raised by an auditor, right, for the most part, or a compliance auditor, an enforcement auditor, whatever. It doesn't matter. It's raised by an auditor. Then eventually it goes to objection. It goes to, when it gets to appeal, we go to court. Then all of a sudden SARS starts employing counsel. The taxpayer starts looking for counsel as well. And counsel goes, shit, you know, there was this particular argument you could have raised. You missed it. And now we've got a problem. So the rule is simply this, right, for the taxpayer. It says you can raise a new ground at appeal stage as long as the issue was placed under objection. So, for example, if a taxpayer objects to the disallowance of an expense, for example, on the basis that the expense is in fact in the production of income, right, for argument's sake, and you get to appeal and you find out, but hang on, there's another section that I can actually rely on, which doesn't require in the production of income because I'm a little bit weak there, but there's this other section that gives me this, I can still raise that because I'm still placing the deduction under dispute. It was placed under objection. I maintain that in appeal just on a different ground. And I honestly think, although there was a while ago, it was quite, you know, debatable as to what is permissible and what not. But I think for SARS nowadays, they're a little bit more locked in, right? So the rule says when you get to appeal, SARS can introduce a new ground as long as that new ground is not an innovation of the factual legal basis or something which requires the issue of a new assessment. Right, so the way I see that, and I explain it in my book and give examples as to what is permissible and what's not, is the way I see that, let's say SARS includes an amount in gross income on the basis that it accrued to the taxpayer, right? Now you get to appeal eventually, and SARS employs counsel, and they say, you know, we can't accrue to, we should go received by, you know? That, in my mind, is an innovation of the legal basis on which they raise the assessment. That's not permissible. I would apply to strike that as a ground, right? So you can't raise that. I don't think they can do that. The other thing they can't do is they can't, for example, effectively bring new issues into dispute at appeal stage. And that's where the rule says they can't introduce something new which would require the issue of a new assessment. So let's say, for argument's sake, you object to manufactured dividends, right? SARS included manufactured dividends of 10 million. Now, when it gets to appeal, they realize they cocked up the numbers. It should have been 20 million rand. They can't raise that as a ground for their assessment because that would require the issue of a new assessment. That's not under dispute. they can go ahead and do that, but that would then have to be objected to as a different assessment. So the rules on that is, it's not all that difficult, but it does get difficult to work with in the set of facts. But you have to bind them to it, because they do that all the time. And we understand why, it's because they employ experts at that point, or they get legal guys involved or whatever. So of course, some of it is permissible, and they'll argue that it is, but you then have to act on that. And the way most people deal with that is to launch an application to have that struck as a ground for appeal. So because they'll typically do that if they know they've got a weak case.
Sure. Well, this is what happens. You're battling back and forth, and sometimes too, you're learning as you go. So part of the problem, I know that, from the taxpayer point of view is that a lot of times you have people who are not litigators. So the fact is that you're a compliance expert, you submit returns, but dealing with the objection and appeal requires a slightly different skill set. And you'll find that sometimes the person who's doing it really they oftentimes don't have enough time to object in time or other kind of things. And they haven't put enough resource into that. And so there are mistakes that are made. So it's kind of a both side thing, but it's important. But there is some flexibility, which is nice to know that's there. Now, just another question here. This one is not paying best, but I'm going to raise it anyway. And that is, somebody was asking about, when is it that their time is up? So one of the issues is, you'll see that when is it that I've conceded the case, I haven't acted fast enough. So there's a big discussion around the 21-day rule. If I don't do my objection in time, I'm dead.
Right.
Now that rule is only on objection. There are other letters and verifications and other things. If you do not respond with your objection in time, then you are in serious trouble. It's very hard to get out of that, right?
Right. So, I mean, you can object so the general rule is 30 days, and then you can get extension, right? And depending on how late you are, you need to prove that either the extension or the delay is reasonable, or that exceptional circumstances existed that caused you to submit late. And that I explain in the time periods in detail in the book. So, but really the objection period is 3 years, right? If you're going to rely on the remedy of objection to try and challenge an assessment, apart from all the other remedies that you've got, then your period is 3 years. And that's not a reference to prescription, right? Prescription on income tax, for example, is 3 years. On that, it's 5 years. But you don't have 5 years to object to a VAT assessment. You've got 3 years. And that's because the time period, SARS cannot extend beyond 3 years. So you've got 30 days up to a maximum of 3 years. After that, you're dead. And with an appeal, that time frame gets shorter. So you've got a maximum of 75 days. After that, you are dead in the water. But for SARS, I mean, when the SARS's time run out, effectively almost never to raise an assessment, right? Because the starting point is, and that's a question I answer in an article, I think it's on my website, is how far back can SARS audit you, really? Because that's what it comes down to. And my view on that is indefinitely. But the further they go back, the harder it gets for the assessment to stick. Because now they start to deal with having to lift the veil of prescription, prove the assessment is reasonable because there's no more documents available. But the long story short is, ideally, one would like to say their time is up 3 years after the assessment was issued. But they can, of course, lift the veil of prescription. They can go back indefinitely. In fact, I dealt with a case where we were busy with, I can't remember the years, where SARS was effectively trying to audit whether a loan advanced to a company or a trust, can't remember, a loan advanced to a company or a trust in 1984 was advanced with after-tax money, effectively auditing the 1985 year of assessment. And the immediate question is, can they do that? Can they go back that far? And the simple answer is yes. Good luck with raising an assessment, though, because chances are it's not going to stick. But yes, in theory, they can do that.
Okay, let me move on here. It's a related question. They go, this is what is saying, if you're out of time to file Rule 56 within 30 days to file an appeal, the taxpayer would not file the appeal in order not to lose the appeal. Would the filing of the appeal affect the outcome of Rule 56? Then he clarifies, if you're out of time to file 56 within 30 days of appeal, the taxpayer would file the appeal in order not to lose the right. Would the filing of the appeal affect the outcome of the 56 application?
Yes.
See if I'm not quite, I'm a little lost in that question.
Yeah, no. So I think the point is, if you are struggling with time periods, you've got to launch this application, but you're out of time. So as a kind of a plan B, you just file the appeal. I think that does jeopardize your Rule 56, especially if your argument is you can't file the appeal, right? You can't comply with Rule 10 because SARS didn't, for example, give a basis, but then you go ahead and file an appeal anyway. You know, that's going to, I don't think, one would have to look at the facts of the case, but yes, I think that does adversely affect the default judgment application. So one has to be very careful. If you do go that route of filing the appeal as a plan B, the wording of that should be very carefully drafted when you file that appeal as a kind of a plan B. But the point is that, I mean, you've got that extension period. So you don't want to do that. That's a last resort, right? So if you file the application for 56, the period gets suspended. Now, you can ask for condonation if you go over the 30 days. In other words, you file your 56 application after the 30 days have lapsed. Well, that then suspends the extra, what's it, 45 days that you can get to file the appeal. So if that application then is not successful, then you'd have to go back, file the appeal, but ask for condonation because you're still within the 75 days because that 56 application suspended. But that's not an ideal position to be in. And also something that's very important to understand is the filing of the Rule 56 application suspends that 30-day or 75-day period. But the rule says the rule that governs that is Rule 50 sub 4, if I remember correctly. It says unless the context indicates otherwise, right? So if you file a default judgment application that's baseless, you're in trouble. Yeah. Because then the 56 or your application didn't suspend the 30-day period. And that is difficult. That's a high risk to take, especially if you're in unprecedented territory like we were in our case. You know, if the court were to have held that SARS wasn't in default or the application shouldn't be there for whatever reason, of course, I would have vehemently denied that. But the fact of the matter is, if that was a possibility, and we were prepared for that possibility as well. So, but it's a good question.
Yeah, interesting. Okay, I think we're having to wrap it up. So I'm just going to, even though I've got a few questions here, I just want to kind of close. The other thing that I think people need to keep in mind is you've been talking about objection and appeal. That's fairly late in the process. There's also the aspects beforehand where you get a verification letter, a 14SD, where you're getting information requests under 46. Now, all of that also has to be carefully managed because that, if it's not managed properly, then you're going to get yourself into a dispute situation.
Yes,
Do
of course.
you find that oftentimes things are at a dispute level because there hasn't really been a good flow beforehand where you found that? And, you know, is there a way to mitigate that? Because that way you're going to actually mitigate the litigation in the first place.
So absolutely. I mean, that's first prize, is to avoid the assessment being raised altogether. And oftentimes the assessment is raised because the responses taxpayers give SARS are just terrible, you know, and in their defense, then raising the assessment, even though it might be wrong ultimately, then you understand why they raise it because the taxpayer really didn't respond appropriately. I mean, and you've got the opportunity to respond, especially if there's an audit, right? So they have to, and you can use all of this, as I explained in the book against SARS, but they have to give you a letter of audit findings and they have to give you an opportunity to respond. Now, ideally, you want to respond to that letter to prevent the assessment altogether. And we've done that many times. I mean, there was an assessment SARS was proposing to raise on another client of ours, also to the tune of a couple of 100 million. Also, by the way, on financial derivative instruments. And the response was very clear, very precise, very well documented, annexed, etc. As soon as you make the auditor's life easy, right? And you explain it to him in a way that's not contradictory to everything you've told them up to that point, then they tend to be lenient and they'll say, okay, fine, we're not raising the assessment, you've explained it. But then in another case I'm dealing with, really the whole dispute, let me not say too much, we're quite advanced into the case. If that had been dealt with properly during audit findings, we would never have been where we are now. But it wasn't dealt with properly. And now you're sitting with what is effectively I think it's actually 80-odd million rand in assessments that could have been avoided. Now we're ready to go to litigation, you know, when really it was just the responses that went out wasn't correct. And oftentimes I find that everybody knows taxpayers bear the onus of proof, right? So everybody knows this. I know we're running out of time. So
Yeah.
Everybody knows this, but very few people seem to really grasp how you go about discharging that onus, right? So we know, yes, I have to prove something. But the first step to getting that done correctly is to understand what is the substantive law say, because that's going to dictate what it is you need to prove. And I always use this example of this, they call it the expat tax. There's no such thing, but be that as it might, the guys with the foreign services exemption, right? So the point is that you have to be outside the country for a set number of days, etc., etc. Right? So as soon as SARS audits those, people tend to give SARS copies of the passport to show you were outside the country. Fantastic. All you've proven is that this person was outside the country for a period of time. The requirement is that you have to work outside the country.
That's right.
So the
That's
fact that you get a copy of your passport, yeah, you've been outside the country, but what did you do then? You know, and that's often where we find that, and I think the reason for that is because people who represent taxpayers inherently believe what the taxpayer tells them. There's no reason to doubt what the taxpayers say. So if you have to discharge the onus of proof, you have to accept that SARS on the other side is going to question every single thing that you say. The fact that you say something in a letter doesn't make it true. Where's the evidence to support that and to support what is in fact the requirements in law? So to properly discharge the onus of proof, you need to have a very firm grasp of what is it that the law says, and then understanding what your options are to discharging or showing satisfaction of those requirements. Contracts, affidavits, passports, you name it, whatever the requirement is, that's what you need to start thinking of to discharge that onus of proof. And when that's dealt with properly, oftentimes you also don't end up in a dispute. You get the matter resolved without getting there. Yeah. Anyways, I think for hours, but it's not.
Yeah, I think your point is, well, this is somebody else pushes this point who's more on the compliance side, but that when you prepare a return, it's simply not just taking a few numbers and throwing it on a return. You need to paper that file so that you can prove, you build your burden of proof when you do the return. And that way your documents are ready. What happens instead is a lot of it's, oh, well, the documents aren't there, but I just believe you. And then you're finding the documents afterward. And maybe it's true, but you're not really prepared. And so you don't have proof, because you're right. The taxpayer does have the burden of proof. And once an auditor is checking around, they can't just go away because the key sweater is going to say, well, what did you do? You didn't really check anything, right? So then it starts looking more aggressive than it has to be. Sometimes it's also just not explaining things right. That's where you also need an expert. I was in a situation where I was just in a dispute and I just wasn't using the right words. I kept telling them that, and I just said, nothing's changed, but you're just not, I'm using a word or something you don't get. And that can be a little bit frustrating. That's there. But again, it's about making sure you have your burden of proof ready up front, and you're not doing it after the fact, only on request. That seems to be a fair amount of the problem.
Yeah, that is also a problem. But I mean, in reality, people tend not to do that. It really is a question of, oftentimes it's easy when the requirement of the law says there must be a contract, right? Then, well, you can prepare for that, you know. But if the requirement in law is something that's not obvious, with what is the evidence going to be, well, that just requires some out of the box thinking. So, well, okay, well, right, this is what the requirement is. How would I go about proving this? You know, what is it? Shall I give an affidavit? Is that going to work? But be careful with affidavits, because they tend to come back and bite you, right? But you can use them. Is it going to be a control account? Is it going to be a bank statement? But anyway, that I can.
Exactly. Okay, now Sarah's looking to shut it down as she sees that I've lost the plot with you and we're having too good of a time. So Sarah, sorry about that.
Thank you. I can see from the feedback and all the questions we've received just how valuable this has been to all the delegates. Thank you so much, Nico, and thank you, Keith, for facilitating. We are unfortunately now out of time, but we will make the webinar recording available a few days after the session, and the details are in, we will send that to you via email. We also have much more detailed guidance in Nico's book, and we're offering a 15% discount to all delegates. At the moment, we're running a 15% off on all our tax titles. And so you don't need to add the discount code for today and tomorrow. Thereafter, if you want to get the 15% discount, you use the discount code TAX15, as you can see on the screen. And that is valid until the end of July. To obtain your certificate of attendance, look out for email in a few days' time. It's important to note that sometimes the automated message can go to your junk or spam folders. So just look out for that in your junk mail. Then, as you can see on the chat, SAIT members can complete a quiz on the SAIT website. The link is in the chat. And really, just from our side, a huge thanks to Nico and to Keith for sharing your insights and expertise with us. I can see everybody's found it so useful, and we look forward to connecting with all of you again soon. So from our side, stay well and warm and safe. Thank you.
Thank you.
Thank you. Thank you. Very useful from our side.